Thank you, Madam Chair, members of the committee. My name is Twila Brase. I'm president of Citizens Council on Healthcare, and this has been an issue for us for a long time since we discovered the DNA warehouse. Started in 1997. We discovered it in 2003, and then, of course, in 2007, the ALJ said that the department was violating the Minnesota genetic privacy law and therefore had to stop collecting, using, and disseminating baby DNA, but the health department has not chosen to do that. The law has been in existence since August 1st, 2006, and here's what the bill does. And it's very important to say that this bill is not about testing. For all this conversation about testing, this bill is not about the testing. This bill is about the storage, use, and dissemination of newborn blood and DNA without the consent of parents. So the bottom line is that the first page of the bill, lines 21 to 24, is the real purpose of this bill. The Minnesota Department of Health is proposing to exempt the newborn genetic testing program from the Minnesota genetic privacy law. This exemption would eliminate the genetic privacy rights of newborns and their families. This exemption would eliminate the informed written consent rights of newborns and their families, the ones they have today. This exemption would eliminate the right of parents to seek legal redress under the Government Data Practices Act when their rights are violated, as they have been for more than a decade while the blood has been taken. The exemption language also seeks to declare that the baby's blood is not genetic information, even though the blood specimen is where the child's unique DNA resides. The rest of the bill, all the other pages, are essentially a description of what the department plans to do after parents and newborn rights are eliminated. So despite no authority to do so, there are now 1.5 million children in the state's database, genetic testing database. There are more than 819,000 children's blood samples in the state's DNA repository, and the genetic information, including the DNA of more than 52,000 children, has been used for research, most of it without parent consent. And notably, until now, there has been nothing to say that the repository would go away. But our concern, as Representative Emmer said, is that it's not going away soon enough. It was supposed to go away 3 years ago. I just want to remind you that last Wednesday, 9 Minnesota families filed a lawsuit using Chapter 13 authority, the Government Data Practices Act, because of the violation of the health department for the last 3 years. And in short, what I want to tell you is that the department is asking you to let them continue doing what they have done illegally. The department is asking you to take the state's largest genetic testing program out from under the protective genetic privacy law. The department is asking you to take the state's collection, storage, use, and sharing of the most private, intimate, detailed data, the genetic blueprint of every child, out of the protections of the Government Data Practices Act. They're asking you to exclude blood and other biological specimens from the definition of genetic information and setting a precedent doing so.
All right.
Furthermore,
excuse me, Ms. Brase, I have a question here from Representative Norton.
Thank you, Madam Chair. You referenced the breaking the law, and you referenced a time frame, but it's my understanding that prior to that, the law was different in the state of Minnesota, and it was okay to keep it, and the law that was changed was done so inadvertently, and that what we've been doing since that time has been trying to fix this so the department isn't breaking the law, and it was an accidental change. So I guess I'm just a little concerned that the story here might be a little misleading, and so I just wanted to clarify that.
Thank
Madam
you, Ms.
Chair.
Brase, please continue.
Yes, the blood testing has been done since 1965 by their own executive decision in 1986. They decided to start keeping the genetic test results. In 1997, on July 1st, they decided to start keeping the blood specimens. There is no law, and as the administrative law judge made very clear, there is no law in statute that allows them to keep or store the blood specimens or to use or share the DNA without the parent's consent. Essentially, there is no law. They just decide to do it on their own. Now, I think a very important thing here is that the department says that they have first dibs, essentially, to the data, that it can be theirs as long as the parent doesn't object. And as long as they de-identify it, then the parents shouldn't care. However, the data, the DNA, the genetic profile of the child is not government property. They are still doing research. It's called test development. And importantly, the child DNA should not be used without consent for either the department's profit or for Mayo Clinic's profit, as is now the case in the area of test development. Another important thing for you to understand is the distrust. I certainly will. As distrust of the department grows, more and more parents are choosing not to have their babies tested. In 2003, the first year they were allowed to opt out, 2 children were opted out. In 2007, 72 children were opted out. In 2008, 89 children were opted out. The parents tell me they're opting out because they don't want the department to have their baby's blood. So thus, we strongly oppose this attempt by the department to undo the genetic privacy law, to eliminate informed written consent, and to say that baby DNA is not genetic information. We urge you to vote against this legislation.
All right, thank you. Representative Emmer, can you be brief, please?
I don't know, Madam Chair. This is an important issue to me, an important issue to my constituents. I'm not the one who scheduled it with this much time, and I'd like to be allowed the time to do what I think needs to be done. Representative Thiessen, I do appreciate your passion on your side of this issue, and I understand your personal attachment to it. Representative Norton, when you talk about Mayo is not a big, bad outfit, nobody's saying they are. And you may not like the position that somebody like me takes on this, but I hope you'll listen, because the biggest problem I have is that it seems to me that a parent's rights should be first and foremost when it comes to their child. I think we should all agree on that. And we keep hearing this legislatively created garbage about a robust opt-out. Folks, there's no such thing. There's either informed consent or there's not. You either have it opting in or opting out. The issue's still the same. Are the parents being given appropriate information so they can make a fully informed decision? That doesn't matter whether you're saying it's on the front end to get into the program or if it's on the inside the program to get out. It's the same issue. This does not afford that. The problem is you need to have some written acknowledgement not only from the parents but from the party that's giving them the information. You have to have an informed consent, and that's one of my biggest objections. I'm going to move an oral amendment at page 2, line 2.35. After the word questions, I would move to strike the period and add the language, and the parents or legal guardians must provide a written acknowledgement of their informed consent to the testing. And with that same amendment, I would move to strike section 8. And I would ask for a roll.
Well, Representative Emmer, I'm going to rule that amendment out of order. I think that's more than we're going to be able to take at this time. It didn't make the 24-hour rule.
Madam Chair, it's an oral amendment. We've taken them in this committee before.
Well, I think it's more substantive than we're going to be able to handle at this point, Representative Emmer, and perhaps you can have that.
Madam Chair, you're not going to allow me to represent my constituents today?
Representative Emmer, that we do.
You're going to rule this committee with an iron fist and not allow people to participate in the process?
Representative Emmer, we're going to move to a vote on this bill.
Madam Chair, I appeal the ruling of the chair.
Absolutely.
And request a roll call.
All right, Representative Broad appeals the ruling of the chair and requests a roll call. The clerk will take the roll. And
A yes favors the chair.
a yes upholds the ruling of the chair, and no vote goes against the ruling of the chair. The chair votes aye.
Thiessen,
Yes.
Abler,
Pass.
Broad,
No.
Bunn,
Yes.
Emmer,
No.
Fritz, Gardner,
Yes.
Gottwald,
No.
Hayden,
Yes.
Huntley,
Yes.
Kelly,
No.
Lane, Loeffler,
Yes.
Mack,
No.
Murphy,
Yes.
Norton,
Yes.
Rood,
Yes.
Howe,
Yes.
Torkelson,
No.
There being 13 ayes and 6 nays, the ruling of the chair is upheld.
Thanks for allowing us
We
to
will move
participate in
to
the
a
process,
vote on the
Madam.
bill. You're out of order, Representative Emmer. Okay, we will vote on the bill. Representative Thiessen renews his motion that House File 1341 be recommended to pass and go to civil justice. All in favor, please say as amended. All in favor,
Madam
please
Chair,
say
there was
aye.
a roll call.
All opposed,
There
no.
was a roll call on the bill, Madam Chair.
Bill is passed.
There wasn't actually, but
Oh, okay.
we should adjourn.
We are adjourned.